Today we're going to be talking about Heath Ledger, the actor. So, Christina, do you want to start by talking about Heath Ledger and giving the background?
Sure. So as most of us know, Heath passed away unexpectedly from what was reported as an overdose. I believe he was about 28 years old. And while he had a will, he had done it a couple of years earlier, about 3 years earlier. So he took the steps at 25 because he knew the importance of having a will. What he failed to do was update his will after he had his child. So he had a daughter. She was 2 when he passed away. But he never updated his will. So his will provided that everything was left to his mom and his sisters and left no provision for his minor child and his only child, or so they thought to be his only child.
Or his girlfriend at the time, the mother of the children.
Correct.
Hmm.
So that shows the importance that while you may have a will and you may have done it, a year or two before, I always tell my clients that they need to come back to see me when any kind of life-changing event, so marriage, divorce, losing a parent, gaining a parent, having a child, any of those things, a child attaining the age of majority, they should come back in and review their estate plan. Even if they don't have a life-changing event, every 3 to 5 years, everyone should look at their will, their trust, their healthcare proxy, their power of attorney, and make sure it's all up to date with what they want. Sometimes, our friendship ends or we get into little, you know, discussions with family members and decide we're not on the same page anymore. So it's always important to keep looking at those documents.
Right, yeah. And sometimes finances change, right? So you might change like how you want to distribute it, or you might inherit money. So any of those changes really warrant like reconsidering your estate plan. And I'm sure Heath Ledger did not think at 28 he was going to die.
And a lot of times I get Leslie with me and my friends as they say, oh, well, I don't really have anything. What do I have? Or I only have a house. Or I only have joint bank accounts. And, I say to them, you have children, you have minors. That's the most important thing, really, aside from your properties, making provisions for them.
He did do like a life insurance policy, and he did name his daughter on the life insurance policy. So that's interesting because he didn't update his will, but he did do the life insurance policy. So it raised the question of, did he really want all the money to stay with his parents? And we'll never know, right? Because he didn't actually update his will. Or did he just not get around to it?
Going back for a second, what you said about the life insurance, you know, they're two different things. So it was probably easier for him to have a life insurance agent who he could call up or come meet him on set or meet him anywhere to sign something quick saying, okay, here's a life insurance policy named so-and-so. Whereas with a will, especially in New York, there's certain procedures that need to take effect in order for it to be signed properly and witnessed correctly. So it would take a lot more to have an attorney redraw up the will, have 2 witnesses present, sign it, notarize it, do all of these things. So people sometimes, say, oh, I'll get to it later and never do. Not dealt with it, but there is an EPTL section that does talk with it, and it goes really in depth. It depends on if the decedent had children already and if they already named those certain children in their will and just failed to name the afterborn child. And then there's portions and percentages. So there's even a part of the EPTL that says that, if you name some children and not all, then the children that are not named may not get anything. So it really depends on situation by situation, circumstance by circumstance.
Is watching this, and you have minor children, we want to emphasize making sure that you name a guardian in the will, because that's sometimes the only way your wishes will be known for who would raise your children after you pass away. And it can also nominate sort of like an exclusion. So I had a client come to me because the father of the child was not ever around. He was never present, and she did not want to die and have the father then step up and try to raise the child after all these years. So that was something we also could take care of legally, is create I forget what I called it now, but a document to exclude him from, to let the court know that the decedent absolutely did not want him to come in and raise the child.
Yes, I had something similar where the mother did not have custody of the children, barely saw them. So we had to make sure that we planned for the event that the father passed away to make sure that the mother wouldn't come back or try to come back. So again, it's really important to have these wills to make sure that the guardian is designated. Had this father not have that provision and he pass away, there's the possibility that the mother would try to get custody of them, or not even get custody, more of guardianship, and that would, put her in charge of their assets and making decisions for them, where they go to school, what activities they do, things that she was never involved in.
Right, and that's a really good point too. So just to distinguish, we have guardianship over the child or guardianship over their assets. So for example, in Heath Ledger's example, I'm sure the mother was still the custodial parent. She's still alive. She's still the guardian, but he may have not have wanted her to control the money, right? Maybe she was a great mom, but she didn't, she had a hole in her pocket and all the money drifted. So he could also have named someone to be financially responsible for the daughter, while not disturbing any of the rights of the mother.